appeal out loud in the matter of Allianz Global Investors GMBH and others, and Barclays Bank PLC and others.
My lords, I was about to embark on the basic principles of English law, and I hope the basics will be uncontroversial. I'd like to underline 4 basics. Number 1, as a general rule, where a tortious duty is owed to a person, that person is entitled to be compensated for losses it has suffered as a result of a tortious act or of the tortious act. Number 2, the compensatory principle requires the court to avoid both overcompensation and undercompensation. Number 3, to the extent that a claimant has avoided any part of its loss, its damages should be reduced accordingly. And number 4, to the extent that a claimant has mitigated or passed on its loss, its damages should be reduced accordingly. Having set out those 4 principles, let me make them
to the extent of, I know it's in your skeleton. To the extent avoided damage.
To the extent the claimant has avoided any part of its loss, damages should be reduced accordingly.
Yes.
To the extent mitigated or passed on, damages should be reduced accordingly. And I'm going to look at the cases to make those good and also to develop them. And the first one, we'll visit some old friends along the way. The first one is British Westinghouse and Underground Electric Railways. That's at Authorities 2 tab 18.
Do we need to go to these?
Well, I was going to take them to you briefly. Some will be more familiar than others. British Westinghouse, I can simply recite the
what
principles, and I'm sure you'll recognise.
Which one of your list is this authority for?
So British Westinghouse deals with the duty to mitigate and with avoided loss.
Yes.
It's tab 18, Authorities 2 at page 364. It's the well-known judgment of Viscount Haldane, the Lord Chancellor. If you could pick it up, please. Second paragraph, the fundamental basis is thus compensation. And if I could ask you to read down to, but not including the paragraph beginning Staniforth and Lyle.
I'm sorry, which page are we on?
So I'm on page 364 of the bundle. It's
yes.
689 of the internal numbering. It's the fundamental basis down to no duty on him to act.
Why does duty to mitigate come into this?
I'm simply trying to clarify what the various principles in play are, and you've seen our pleading, which refers to avoided loss, mitigation, and pass on. So by looking at these authorities, I hope to try and tease out what the differences are.
This is about duty to mitigate.
It is the first.
There was no duty on the appellants to mitigate by redeeming the shares.
I'm going to come on to mitigation because, as we'll see in a later authority, the Supreme Court has held that pass-on is a form of mitigation.
I understand that, but this case was all about the scope of the duty to mitigate.
I understand. So what I'm showing you is the fundamental basis section is identifying that there is a duty to mitigate, and the paragraph that begins, as Lord Justice James indicates, is that even where there is no duty to mitigate, avoided loss has to be taken into account, and that clearly is front and centre in our case.
I don't think we have any difficulty with the propositions about the duty to mitigate, mitigated loss, avoided loss. The question here is simply, is this avoided loss?
I'm going to come to that immediately. That's my next point.
And how does it arise on this appeal?
That's where I'm headed. It's literally my next point. So the next authority I want to go to on avoided loss is the Swinson judgment. That Authorities Bundle 4, tab 38. If you could turn to page 1081 of the bundle. paragraph 11 in Lord Sumption's judgment, which you saw yesterday. Again, you saw it yesterday. If I could ask you to read paragraph 11, all of it, so down to F on page 1082, please. Now you have the points I made yesterday that this strikeout is based on a pure point of law, that res inter alios acta was not argued below because it's not an issue. But you asked me the question yesterday, my lady, well, how would the argument run? Now, bear in mind, please, that this has not been argued below, and neither party has set out in its skeleton arguments what the arguments would be. But the way we would put the argument is this, when the moment arose. If you go to page 1082, opposite B, Lord Sumption explains, broadly speaking, collateral benefits are those whose receipt arose independently of the circumstances giving rise to the loss. So our argument will be, if res inter alios acta is raised by the claimants, here, as I've shown you, the assumption on the pleadings from the voluntary particulars is that the wrong caused harm to the claimants, and further, as a result of that wrong, the claimants paid out less by way of redemption payments. So the same infringement is said to give rise to the loss to the claimants and to the benefit or the avoided loss that the claimants get as a result of making reduced redemption payments. So that's to show that we're in the game, if you like. But clearly what would have to happen, and one sees it in Swinson, paragraphs 12 and following, is there would have to be an assessment of the relevant facts. And those facts simply aren't before this court, and they went before the court below. So that's why...
But that's because it was a strikeout of paragraph inter alia 15 of your further medical particulars, which asserted avoided loss. And at the hearing before the judge, when the judge sought to clarify it with you, you said that the entire case was about pass-on, and that in order to establish it, you had to show that the loss was passed on by way of the investors acquiring a claim, and that was fleshed out with you. So you did not seek to save that assertion by saying what you're now saying.
Well, with respect,
when now you do assert it, why can't properly the answer to that be raised in this court? Well, you couldn't say this and that, and no doubt that's why you didn't say it, is because it's raised inter alios acta.
2 points in relation to that. One, as we've set out in our supplemental skeleton argument, that's not, with respect to an accurate reflection of what happened below. We didn't at any stage give up the avoided loss argument. The judge asked me a question about whether, as a result of pass-on, that would mean that the beneficiaries would have to have a cause of action. And as we've explained in our supplemental skeleton, the answer I gave was that if it is correct that as a matter of EU law, anyone who has suffered loss as a result of an infringement of Article 101 has a right of action, then it follows that if there is pass-on, then the person to whom the loss is passed on will have a cause of action.
What was your answer to the strikeout of the phrase avoided loss then?
It was the arguments that I'm putting now.
No, you were not suggesting for a moment that you didn't need to establish title to sue on the part of the recipients under pass-on.
My argument was that pass-on and the title to sue are separate things.
No, you said you were inextricably linked. You accepted in terms that you had to establish.
Can I take
Unless I've misread the transcript.
Well, let's go to that point.
Yes.
There's a second point to this. I'll come to the transcript on that about what went on below. But even if it were correct that we didn't argue avoided loss in that way below, but I'll show you that it was live below, it would still be the case that the evidence for this court to make a ruling on collateral benefit is not before this court.
Well, it goes back to the questions my Lord or Justice Peter Jackson opened with, which is, what is the scope of our remit here?
Yes.
And you said, pragmatic, we want decisions on the law. That must, if res inter alios acta does properly arise responsively to a new argument, and obviously you don't accept that, then surely as a matter of principle, we ought to be able to decide it. If there is any merit in the suggestion there has to be a detailed assessment on the facts, then the judge's solution was to say, well, that factual arguments would be open to you if they genuinely are relevant or impact on the findings of law.
My lady, in response to Lord Justice Jackson's question, I agreed that the issue should be decided as a matter of law. And as a matter of law, it has to be decided on the basis of the pleadings. And you have the pleading in paragraph 15 of the voluntary particulars, which says that as a result of the wrong, the funds made payments by way of redemption that were lower than they otherwise would have been. Now, if those are the assumed facts, in my submission, it is not possible, with all due respect, for this court to make a finding of collateral benefit, because the assumed facts are that the benefit arose out of exactly the same wrong, which is the basis of the claim put against us. That is, with respect, that is the confines of the Strike Act. And any facts beyond that, for example, to challenge 15, well, paragraph 15 hasn't been challenged. The Strike Act's brought on the basis of a pure point of law, and there are no other facts before this court. It was not dealt with in witness evidence by either side.
Well, certainly the way I'd understood it was that you were effectively saying that the phrase mitigated, avoided loss, or pass on were all looked at compendiously, and your answer to the strike out of that was as you advanced it before the judge. And I thought that was fairly well clarified by in argument, and that was the basis the judge proceeded on. And if there was going to be a separate argument about avoided loss, surely the time to have had that would have been when the judge was determining whether to strike out those words.
Well, with respect, we pleaded avoided loss, mitigation, and pass on. And in the strikeout application that was made against us, res inter alios acta was not raised. Now, it is for the person...
That's because you didn't argue what you're now arguing, which is that you weren't arguing that is a separate question about whether or not loss has been avoided without necessarily imbuing the investors with a cause of action.
Well, let me show you what the nature of the exchange I had with the judge was, because it was, in my submission, restricted to pass on, and the judge misunderstood the nature of the submission. So, it's judgment paragraph 11, so that's core bundle paragraph 10. It's at page 113. Paragraph 11, about 5 lines from the bottom. It was apparent from the manner in which the defendants presented their arguments and expressly accepted by leading counsel for the defendants in his oral submissions that a successful plea of pass on required that the person to whom the loss had been passed on had his own right to sue in respect to that loss. This is not a feature of other types of mitigation, it is a feature of pass on mitigation. So the exchange that's recorded in the judgment relates solely to pass on and mitigation. And I've shown you in the voluntary particulars, we put a case based on avoided loss, mitigation, and pass on. So this exchange and this recording of what I'm said to have accepted relates only to mitigation and pass on and not avoided loss. Now, to make it absolutely clear what we say the law is on this, is that it is not correct that as a matter of law, a successful plea of pass on requires that the person to whom the loss has been caused, has been passed on, has its own right to sue. The word we take issue with in that passage of the judgment is the word required. This becomes quite a narrow point. In our submission, the judge has conflated the principle of mitigation, pursuant to which a claimant cannot claim for losses which it has avoided or passed on, and the right of a person who has suffered independent loss as a result of the wrong to claim damages for that loss. So under the first principle, mitigation or pass on, if there is evidence that a claimant has passed on any part of the overcharge or otherwise reduced its loss as a result of the overcharge, the compensatory principle mandates the court to take account of that, and there will be a question of mitigation of loss. So that's the first principle, mitigation of loss. And in our submission, under the second principle, the right to claim damages, any person who suffers loss as a result of a breach of EU competition law has a right to claim damages. But those are two separate principles. And what the judge has done is to align them to say that in order to make good a pass-on or mitigation argument, it is required that a third party has a right to sue.
Well, you can't blame him, can you, on the back of the exchange that you had? I mean, you said must have his own right to sue. That is right. What's the difference between must have and be required to?
My lady, I'm happy to, I've got a broad enough back, but with respect, I think what's happened is there has been an exchange between myself and the judge. The judge has understood it in a certain way by filling in certain gaps, but that was not what I intended to say, and with respect, it's not what I did say. If I can show you what our skeleton argument was on this.
What's the transcript reference?
So the transcript is, I'm going to go to the supplemental bundle. I'd like first of all to go to our skeleton argument,
Right.
and then I'm going to go to the transcript.
Thank you.
So our skeleton argument below is supplemental bundle, tab 11, page 191. And if I could ask you to read paragraph 23, A and B. So you'll see there the distinction that I've just made to you in submission. The notion of mitigation or pass-on is separate from the right to sue of a person who has suffered loss.
So sorry to rise, but while you're on this, could you also please look at paragraph 4, which we've referred to in our skeleton, page 182, which says pass on encompasses avoided loss. And I'm afraid that is the basis on which the whole hearing below proceeded. And our...
Yes, all right, we'll just look, we'll look at paragraph 4.
My Lord, can I just make one further point, because it relates to the fact that in the bank's respondent's notice, they seek to withdraw their concession. And we accepted that on the basis that it raised a pure point of law. But if it's now being said, well, there has to be this whole other factual investigation of the point.
You withdraw your concession.
We don't accept that the concession can be withdrawn.
So that's...
I'm just reading paragraph 4.
Of course.
What do you say about paragraph 4?
It says what it says.
Well, I know it does. What do you say about it?
Exactly. So I say that one of the reasons I'm going through the fundamental principle of English law is to try and tease out the differences as a matter of law between avoided loss, mitigation, and pass on. And
Mr. Hoskins, it seems to me that what we're talking about here, before we get on to what this appeal is really about, is a situation in which the parties went before the High Court, argued the whole thing out with a view to deciding whether there was going to be a vast discovery exercise or not. Mm-hmm. And that these fine differences that you're now seeking to put at the forefront of your submissions to us were not present during that exercise, because the parties then seemed to be taking a practical approach, something that you've confirmed to me when this hearing began. You appear to have gone into reverse gear since then in the submissions that you're now making, and seeking to introduce a distinction which was not understood, not even understood by the judge, who was spending 3 days deciding a preliminary issue of this kind. I mean, you have the time that's available to you,
Yes.
and you can spend it as you wish. But we will finish this appeal today, and you can, as it were, take your own course.
Well, I'm happy to do so. I mean, the issue about avoided loss being a separate issue was also raised by a question by Lord Justice Phillips yesterday, which is why one of the reasons I'm addressing you on it.
Yes.
You have my submissions as to what occurred below. It was pleaded that avoided loss, mitigation and pass on are all relied on. Our skeleton at paragraph 23 made a distinction between them. At the transcript, which is at supplemental bundle at tab 18, the judge asked me a question specifically about pass on. He didn't ask me a question specifically relating to avoided loss, even although we have a distinction in paragraph 23 of our skeleton in relation to that.
Can I just catch up? It's paragraph 18. Page?
So, sorry,
18.
supplemental bundle, tab 18, it's page 336. It's page 69, line 13 to page 70, line 15 of the transcript. I'll give you a moment to refresh your memory on it.
Right. The point arising out of that is that you were answering it by reference to pass on only.
That's right.
And not to pass on as being the same as everything else in the way that your skeleton argument
Correct.
described it.
That's correct.
And you thought the judge was asking you just about pass on and not about the whole thing.
I did.
But read on, Mr. Hoskins.
Sorry,
Pass-
which
because
bit?
pass on is a species of mitigation,
Yes.
which echoes back to paragraph 4.
Because it also echoes back to the Sainsbury's case that I'm now about to take you to. But in my submission, there are concepts in the law of mitigation, pass on, and avoided loss. And there may be some instances where they overlap, but they are actually, at their core, independent concepts.
All right.
So I would not accept, for example, that avoided loss is simply a species of mitigation for the reason that Lord Justice Phillips, Lady Justice Carr put to me. The difference one sees in British Westinghouse between the duty to mitigate and then the second principle I took you to, even if no duty to mitigate, there can still be avoided loss. Now that shows very clearly that avoided loss is not the same as mitigation.
So can I understand the consequences of your submission? Because really you're saying to us that res inter alias acta is out of bounds for this appeal, and that if that's an argument, then it's all going to have to go back and be argued again?
Well, it would come, if the strikeout couldn't succeed on that basis, and therefore it would still be live in the action, absolutely.
And what, you will go round the same course again?
No, because in our submission there wouldn't be a strikeout because it's too fact sensitive. It would be dealt with in the trial.
Could you just in the very broadest way explain what facts are sensitive that would not have been sensitive for mitigation and avoided loss?
Well, our case, as you've seen pleaded in paragraph 15, the voluntary particulars, is that as a result of the wrong, the funds paid less by way of redemption payments than would otherwise have been the case. In our submission, if those facts are made good, we satisfy, we're not in the realm of res inter alias acta because of the dicta of Lord Sumption at paragraph 11 of Swinson. If the claimants want to say that those pleaded facts are incorrect, then of course they can do so. But they would have to raise that point, they'd have to bring forward...
Does it follow, and I'm just trying to feel my way to the consequences of your submission, but does it follow that even if the strikeout application had succeeded, on your case, it wouldn't have avoided the discovery exercise anyhow.
Because if the strikeout application had succeeded in toto, it would have taken out the avoided loss plea as well. So if the strikeout application had succeeded, it would have taken out avoided loss and mitigation and pass on. And so therefore disclosure that was solely relevant to those issues would not have been relevant in the action.
If you have, if there is avoided loss, if a loss has been avoided, you never get to any of these arguments. You don't, I mean, arguing about whether or not the investors have a claim only and you have a pass-on defence, only arises if the claimants haven't avoided their loss.
So if the claimants haven't avoided them?
Yes, if they've avoided their loss, you don't need to worry about whether or not the investors have a claim. I mean,
No, I agree, absolutely. So the way I'm putting this is I'm going to address you on, let me give a scheme. So our submission is a person who suffers loss as a result of a breach of Article 101 or Section 2 of the Competition Act has a right of action. Then what the claimants say is, no, because where you're dealing with a company, the reflective loss rule applies. And I'm going to submit that it doesn't. And then they say where it's a trust, only the trustee can sue. I'm going to say that's incorrect. And they say the same for partnership. And then the avoided loss point comes in, well, exactly where you said yesterday, in a sense. Even if the claimant is right on all those arguments, and therefore the beneficiaries do not have a right to sue, there's still the question of avoided loss. Because avoided loss does not require a third party to have a right to sue.
It's the other way around.
It simply requires loss to have been
Isn't it
avoided.
the other way around? Before you look at whether or not, before you look at the issues of the investors and whether or not they have a claim and whether any loss they've suffered is reflected, the first thing you say is, what is the company's loss? And that involves looking at issues of mitigation and avoided loss. And it seems to me that if you were going to say, well, if you're saying, well, look, this is arguably avoided loss, then all the arguments you had before Mr. Justice Teare and have been having here are to naught.
I completely agree that you can take it that way. The problem is when one comes to the question, has the company suffered a loss, one has to look at the case law on reflective loss actually to find out the answer to that.
I just don't see that. Reflective loss is, the question of reflective loss is whether a third party, such as the investors, can claim for the company's loss.
No, yes, because my submission is going to be that reflective loss doesn't cover a situation where, for example, an ex-shareholder has suffered its own loss that the company cannot claim for.
Yeah.
I don't think we're a million miles apart, but I understand how you fit these bits together is not clear. I've explained the way in which I was going to take you through it, and I think actually looking at the cases on reflective loss helps one decide the question of whether the company has avoided loss.
What I understand the consequences of all this would be is if we were against you on the points that we heard about yesterday, you would be saying to us, will you strike everything out except for the reference to avoided loss?
Precisely.
Which makes a bit of a nonsense of the whole exercise that we've been engaged, that Mr. Justice Teare and we were engaged in.
Well,
it's going to have to be full disclosure of what happened with investors in order to ascertain what the avoided loss was.
but that would be absolutely appropriate, because in that circumstance, there'd be a valid pleading of avoided loss. Of course there should be disclosure in that circumstance.
Isn't there some, in this field of law where we're dealing with national institutions, isn't there some understanding, to put it mildly, that the parties assist the court to deal with the issues that really matter, and don't simply put a key under the doormat and pull it out later after the whole thing has gone ahead? I mean, it really seems to me that the way in which this argument is going makes the whole system seem rather disreputable.
Well, I say my back is broad enough if that's how the court feels, but with respect to both myself and Mr. Mitru, the issues here are complicated.
But the
And
judge,
we have.
I'm sorry to talk over because you haven't a chance to reply to what I said, but reading the judgment, the judge thought that he was dealing with certain matters in order to control the onward practical consequences of this very large and important piece of litigation. I mean, isn't it, for example, if this was a point that was going to remain alive, wasn't there an obligation upon somebody to draw his attention to that and say, well, there's no point in you striking all this out because you're going to have to do it all anyhow?
Well, Lord, what happened below was we made the pleading, which you see at paragraph 15 and elsewhere, the voluntary particulars. The claimants then put forward their arguments against it, which were based on the reflective loss rule, the rule that they say relates to trust, the rule that relates to partnerships, and we had to meet those arguments.
But
that's why.
So isn't this? I mean, this is not a debating society.
No.
In which people are putting forward legal arguments just for the sake of putting forward legal arguments and seeing how good they are at it. It's to do with practical matters that have real-world implications for real people.
Yes.
So, I mean, it's not just a question, is it, of saying, well, they put up an argument, we answer with an argument. The judge went into all of this, what the practical consequences were either way for your case or their case.
Well, he didn't go into the practical consequences with respect. He was dealing with a pure point of law. And when I come to this court, I consider it to be my obligation to the best of my abilities, to try and clarify what the relevant legal principles are. And part of that obligation is to try and identify the difference between avoided loss, pass on, and mitigation. So my coming to the court is in that spirit of trying to assist the court, which has to decide points of law. Now, it seems to me the fundamental duty on my part is to try and clarify what those principles are so that the court can then make its decision. And that is what I am endeavouring to do in good faith.
I mean, the solution may be if you're, and nobody's, well, no question of that, Mr. Hoskins, but it may be that if it is right that on a fair reading of everything that happened below, you are running arguments in a different way, and I know you don't accept that, but if that is right, and the consequence is then it gives rise to all these further complications, the solution is not to allow you to run the new point.
Well, that's obviously within this court's power, but you have my submission that this was pleaded below. We responded to the strikeout that was put against us, and the exchange I had with the judge was based on pass-on stroke mitigation and not avoided loss. So you obviously have that power, but you also have my submission as to why it would be inappropriate to exercise
And it's
it.
paragraph 1 of the respondent's notice at page 16 of the core bundle that contains this.
That's right.
Yes, thank you.
That's right. And also, in my submission, it would be unsatisfactory in a case of this importance, raising issues of this importance for an appeal to be decided on that sort of procedural rather than deciding the law.
I absolutely see that. None of us. We all want to make as much progress as possible. There are all sorts of potential problems along the way arising out of some of the tensions that the judge had to deal with below as well.
Can I move on to no?
Yes, please do.
I'm aware that obviously you need to ask me all the questions, but I take Lord Justice Jackson's direction very seriously. I have to finish.
Well, just one further point about it. You did have quite a bit of debate with the judge about whether or not the facts were relevant to these issues. And it seems to me that you said to him that, well, issues of foreign law might be relevant.
Because res inter alios acta had not been raised by the claimant. It wasn't raised below, and therefore, if it had been, I would have given the answer that
but then
the
your
facts
answer,
are relevant to that.
Well, your answer in that case would have been, well, look, we don't need to worry about all this because it's avoided loss, and they're not suggesting any answers. So
that might have been a quick way.
The first thing you say, paragraph 1, your skeleton, there may be issues about pass on, but as far as avoided loss is concerned, it's a matter of fact, and there's no suggestion that it's not arguable. So don't strike that out. Okay, we have the other arguments, but it's not going to get us anywhere because we're still going to need disclosure. Surely these are matters that we can, in that case, leave to the trial judge.
That might have happened.
But you didn't. You said to him, no, there are no factual issues here in this strikeout.
Because the claimants hadn't raised res inter alios acta. It simply didn't come up. And it's like, that's for the claimant to raise, not for us to raise, with respect.
Factual issues on a question of avoided loss, you're going to have to look in detail.
My lord,
my difficulty with it is that your answer to the strikeout, it seems to me, was to resist the arguments on that were being advanced on reflective loss, causes of action, etc., and pass on. And what is the assumption that a court would draw from the fact that you are not saying that this is a simple case of avoided loss because they have gained a benefit consequent on the cause of action? And it seems to me the only reason for that would be because you accepted or recognised that this type of avoided loss was not recoverable in a straightforward way. Which is why you were entering into these extensive debates and saying, yes, they're points of law, which facts are not relevant. And Mr. Hoskins, the idea that you and your extensive team would not have said to the judge, well, this is all very well, but avoided loss is going to have to go to trial anyway. The fact that you would not have said that to the judge if that was what you were pursuing, I find that difficult to accept.
Well, it is what it is. That you have what happened below. You have my submissions on what our pleaded case was. You have my submissions on what the scope of the strikeout was. You have my submission that if the claimant wished to raise res inter alios acta, it was incumbent upon it to do so, and it did not. Hindsight is a wonderful thing, but I am here addressing you on points of law, and as you yourself raised yesterday, avoided loss is clearly one of the issues of law that arises on this appeal, and I've addressed you on it. If the court wishes to take a view on the way the matter was conducted below, as I said to Lady Justice Carr, so be it. But you have my submissions as to why it would be inappropriate for you to do so. Shall I move on?
Yes, please.
Can we go next to Sainsbury's and MasterCard? That's Authorities Bundle 4 at tab 42. And this authority deals with the principles of pass-on in particular. Pass-on as a species of mitigation. If we can pick it up, please, at page 1257.
Sorry, Mr. Hoskins, I was just making a note of what you've just said. Can you just read it again?
It's Authorities Bundle 4, tab 42, and I'm at page 1257. Paragraph 194. It is trite law that as a general principle, the damage is to be awarded for loss caused by tort or compensatory. The claimant is entitled to be placed in the position it would have been if the tort had not been committed. I'm not going to teach you to suck eggs, and that's absolutely well established. Could you next please read paragraphs 195 to 197? So you'll see that what the court is saying is that in the United States, precisely because of the sorts of issue of complexity, uncertainty and cost, the Supreme Court has adopted a decision based on legal policy that only the first harmed person may sue, and it doesn't matter what happened in relation to pass on. And the Supreme Court is saying quite clearly that is not English law, regardless of the potential complexity in tracking this down. This in English law is a matter of principle. And that is the base upon which it must be decided. So we are very much in the realm of principle. And then if I can ask you to turn to page 1259 and read please paragraphs 205 and 206. And in particular, when you're looking at the 4 principal options, it's option 4, Roman 4, I'm concerned with.
Thank you.
And you'll see in the final sentence of paragraph 206, the Supreme Court held, if a claimant has passed on the costs caused by the infringement to its customers, the compensatory principle mandates the court to take account of their effect. And there'll be a question of mitigation of loss. Now bear in mind here, we are dealing with the customers of Sainsbury's. So you see the number of potential people who could take this point. But it's quite clear from what the Supreme Court says that the number of people who might benefit from such an argument does not matter. It is a question of principle. And then at 1261, paragraph 215, again, if I could ask you to read that to yourselves, please. And please note that having cited British Westinghouse, what the Supreme Court says is that that issue of whether a claimant has avoided its loss raises both a legal issue of causation and factual issues. Then paragraph 217, so on the same page, if I could ask you to read that to yourself, please. And that's where I get my principle that the principle of compensatory damages is as much about avoiding overcompensation as undercompensation. And then the final authority I'd like to take you to in relation to these fundamental principles is Marex. I'll come back to it in more detail for the reflexive loss rule, just for this general principle. It's Authorities Bundle 5, tab 43. If you could go to page 1288. It's the judgment of Lord Reid at paragraph 9. If I could ask you to read down to C and the words, that's general rule. So the first 5 lines. And you'll see that what Lord Reid is explaining is that the general rule is that a claimant is entitled to be compensated for wrongs done to it. And there is a highly specific exception to that rule, and that is the reflexive loss principle, which is a rule of company law. So the general principle is you're entitled to be compensated for wrongs done to you. I'll come back to Marex in more detail for the reflexive loss rule. I'd like next to look at the nature of competition claims. Under English law, an individual who has suffered loss as a result of a breach of Article 101 is entitled to bring a claim for damages for breach of statutory duty in respect of loss caused to it by that breach. And that's long established. If we go to Garden Cottage Foods, it's Authorities Bundle 2 at tab 20. in the speech of Lord Diplock, and it begins at 411 of the authorities bundle, so right at the bottom of the page.
Sorry, page.
So 411.
Thank you.
Article 86 is in the following terms. Then he sets out Article 86. Now, Article 86 is now 102, so it's one of the two main competition law rules. But then if you could read, please, from C to E and finish with the words loss or damage is caused by a breach of that duty.
Sorry, wrong page.
It's on page 412.
So you'll see, to put it in context in our case, the English law provides that a breach of here, Article 101, is to be characterised in English law as a breach of statutory duty that is imposed for the benefit of private individuals to whom loss or damage is caused by a breach of that duty. We go next to the appellant skeleton to see what they say about this. So, core bundle, tab 1, tab 5, page 44, core bundle, tab 1, sorry, core bundle 1, tab 5, page 44. And can you please read paragraphs 26 and 27? This is the claimants skeleton. So you'll see they themselves rely upon garden cottage. Indeed, that's what they base their own cause of action on. And then at 27, they say the position is the same in relation to Section 2 of the Competition Act. It gives rise to an action for damages for breach of statutory duty where loss or damage is caused as a result. So that's the basic principle in this case. We say where a person has suffered loss or damage as a breach of Article 101 or Section 2 of the Competition Act, they have a right to bring a claim for damages based on breach of statutory duty. And the question one then moves on to is that right removed, for example, as a result of the reflective loss principle, which is where I'll begin. But there is a general right, and the question is whether it is taken away. So I'm moving into company law. I'd like to take you to prudential, which of course is where the rule in Marex, the rule that's debated in Marex comes from. That's Authorities Bundle 2, tab 19. And very briefly, the facts were that B and L were officers and employees of Newman Limited. They prepared a circular containing false statements which recommended that shareholders vote in favour of a proposal to purchase the assets of a company at TPG. And Prudential claimed in its capacity as a shareholder in Newman Limited. You see that on page 386 of the bundle, opposite D. The plaintiffs being Prudential. Could I ask you please to read on the same page from E to G. So down to the words being left to an inquiry. And you'll see there that the first instance judge, Mr. Justice Feinlott, upheld Prudential's claim on the basis that the fraud had caused Newman Limited, the company, to suffer a reduction in net profits, which must have affected the quoted price of Newman shares, thereby causing the plaintiff some damage. As we know, the Court of Appeal overturned that finding.
After a hearing which seems to have gone on forever.
Well, I guess that's an occupational hazard.
Those were the days. I mean, it
Indeed.
was like a 20-day appeal.
I wish I had the luxury of that time. I feel a bit like the White Rabbit, I must confess. If I could ask you next to read, please, 22G, in our judgment, the personal claim is misconceived, and over the page to B, you'll see what the Court of Appeal said.
Sorry, 2-2.
So, still on the same page, 222G. So that's page 386 of the bundle. Sorry, I'm referring to the...
Yes, internal.
I'm so sorry.
Yes.
So you see, between G and H, the Court of Appeal held that where a person owes a duty to shareholders and breach of that duty causes the shareholders to suffer personal loss, the shareholders will have a cause of action in respect of that loss. So the reflective loss principle is not simply shareholders can never claim. They can claim if a duty is owed to them and if they suffer a loss which is distinct from that of the company. And then at A to B, over the page, the Court of Appeal held a loss in value of shares is not a personal loss. It is merely a reflection of the loss suffered by the company. An explanation that's given is that is because shares are merely a right of participation in the company on the terms of the Articles of Association, and the shares themselves and the rights of participation are not affected by the wrongdoing. And as a result of the wrong, the plaintiff here, Prudential, still holds all its shares as its own absolutely unencumbered property. So that's how the Court of Appeal explained its rule as it became in Prudential. So let's go to Marex, which is obviously the reconsideration or the consideration of that rule. That's Authorities Bundle 5, tab 43. Before we go to the detail, in our submission, Marex establishes the following three principles, certainly for the purposes of our case. First of all, a shareholder will not have a cause of action in circumstances where, if the company has a cause of action and were to exercise it, that would compensate both the company and its shareholders. And the application of the rule does not depend on the company actually pursuing its cause of action, but the company must have a cause of action.
Is that the second principle or part of it?
That's all still part of the first one. The second principle is that the rule in Prudential is premised on the fact that a shareholder can exercise such rights of control over a company's decision making as have been granted to it by the Articles of Association. And the third principle is that where a shareholder suffers a loss separate and distinct from that suffered by the company, caused by a breach of duty owed to the shareholder may sue to recover the loss caused to it by breach of the duty owed to it. And I'll make good those three principles as we turn to the judgment. Going back to page 1288, I've already shown you paragraph 9. You were shown by Mr. Mitru paragraph 9, the final sentence. Prudential is a rule of company law. It's a specific exception that applies in company law. It doesn't apply to trusts or partnerships. Then at page 1291, You'll see the heading above paragraph 23. This is where Lord Reid considers prudential insurance. Paragraph 23 at C, Lord Reid says, in more recent times, the courts have had to consider the position where a shareholder seeks to recover damages in respect to a diminution in the value of his shareholding or in the distributions received from the company, resulting from a loss suffered by the company in respect of which the company has its own cause of action. This issue appears to have arisen for the first time in Prudential. And then if I can ask you please to read paragraphs 26 and 27. In particular, it's 26b I'm concerned with, the rest is a recitation of Prudential. And you'll see that at 26b, the court says that Prudential was concerned only with the diminution in the value of shares or in distributions suffered by a shareholder merely because the company had itself suffered actual damage. It was not concerned with other losses suffered by a shareholder. So that makes good my point that the reflective loss rule doesn't bar all claims by shareholders, only those which fall within the strictures of the reflective loss rule.
Well, that appears very clearly from Johnson and Gore, doesn't it?
It does, absolutely, yes.
Yes.
As long as we're looking at Lord Bingham and not Lord Millett.
Yes, but I mean, look,
But yes.
Marix is the latest word, but it's by no means new law on any of this, is it? I mean, this is pretty much following.
That's right. This isn't
Johnson
controversial.
and Gore.
This aspect wasn't controversial. No. But it's the easiest way for me to show the principle. Paragraph 28. You were shown this by Ms. Dimitru, but just for the purposes of my argument, could you read that again, please? So what said is that in the circumstances where the reflective loss rule applies, the shareholder is not considered as suffering actionable loss, which is distinct from that of the company.
Forgive me, but what this is all leading up to is that you're going to submit to us that the position is different here.
Yes. Absolutely.
Well, I think the basic principles, for my part anyway, the basic principles now are pretty clear. I think what you've got to persuade us of is whether or not the situation here doesn't fall within these principles.
I understand. I'll get there. Some of the submissions I want to make on why this is different depend upon the reasoning. So if you just bear with me, but I'm coming to the crunch. Page 1293. Could you please read paragraphs 31 to 33?
These we did read yesterday, didn't we?
I'm sorry, you saw certainly 33, but if you've already read 31 and 32, then
yes.
I can take it quickly. Paragraph 33 at G to H. The Supreme Court indicated that in circumstances where an award of damages restores the company's position to what it would have been if the wrongdoing had not have occurred, where that would also restore the value of the shares, the only remedy which the law would require to provide in order to achieve its remedial objectives of compensating both the company and its shareholders would be an award of damages to the company. And therefore, a shareholder will not have a cause of action in circumstances where, if the company has a cause of action and were to exercise it, that would compensate both the company and its shareholders. But in our submission, it follows that where the company does not have a cause of action that would compensate the shareholders or the ex-shareholders for a particular loss, then the ex-shareholders can sue in respect of their loss. So the reflective loss rule assumes that the action by the company will compensate the loss suffered by both the company and the shareholders.
Could you repeat the statement of principle that you've just given us?
Certainly.
I mean, it was a single sentence, which I'm anxious to get done correctly.
Certainly. So you've seen what the court held at G to H. A shareholder will not have a cause of action in circumstances where, if the company has a cause of action and were to exercise it, that would compensate both the company and its shareholders. So that's what was held in Marex. My submission is that it follows from that where the company does not have a cause of action that could compensate the shareholder or ex-shareholder for a particular loss, the shareholder or ex-shareholder
Slowly. Shareholder or
ex-shareholder for a particular loss,
Yes.
the shareholder or ex-shareholder itself can sue in respect of its loss. And then over the page at 1294, paragraph 35, so at the bottom of the page opposite H, if I could ask you to read from H to the end of paragraph 37.
Thank you. Yes.
I make the following points in relation to that. Paragraph 35H, where a shareholder invests in a company, he entrusts to the company, ultimately a majority of the members voting in a general meeting, with the right to decide how his investment is to be protected. Paragraph 36, in a situation where a shareholder claims that his shares have fallen in value as a result of a loss suffered by the company, and the company has a right of action, and I stress these words, in respect of that loss, the shareholder can exercise such rights over control over its decision making as have been granted to him by the Articles of Association. And in 37 at E, it is for that reason that the rule in Prudential has been said to recognise, I quote, the unity of economic interests which bind a shareholder and his company. Therefore, in our submission, the rule in Prudential is premised on the basis that a shareholder is able to exercise rights over the company's decision-making according to the rights granted under the Articles of Association. Paragraph 39 is the summary in relation to Prudential, but it's the final sentence I wish to draw your attention to. The decision in Prudential had no application to losses suffered by a shareholder which were distinct from the company's loss, or to situations where the company had no cause of action. And it's the first of those that I am going to particularly rely upon. And then you'll see in the middle of page 1296, Lord Reid then went on to consider the judgment of the House of Lords in Johnson and Gore Wood. Paragraph 41, he cites three principles that Lord Bingham recognised in that case. And if you look at over the page 1297, the third principle by B, I could ask you to read from B to C, Lord Bingham's third principle.
Yes.
That's the principle that we in particular rely upon. And at paragraph 67 on page 1304, Lord Reid, 4 lines up to the bottom of paragraph 57, Lord Bingham's speech is consistent with the reasoning in Prudential. He says that that of Lord Millett is not. So he approves the principles that Lord Bingham expressed as following from Prudential. And then on page 1307, the summary, you've already been taken to this by Ms. Demetriou. So I can take it quickly. At F, Lord Reid held, depending on the circumstances, the company's recovery of its loss may have the effect of restoring the value of the shares. In such circumstances, the only remedy which the law requires to provide is an award of damages to the company. So that repeats the point we saw earlier in the summary. Paragraph 81 at H. There may, however, be circumstances where the company's right of action is not sufficient to ensure that the value of the shares is fully replenished. Gives one example. Then another is where the company fails to pursue a right of action, which in the opinion of the shareholder ought to have been pursued, or compromise its claim for an amount which in the opinion of the shareholder is less than its full value. But the effect of the rule in Foss and Harbottle is that the shareholder has entrusted the management of the company's right of action to its decision-making organs. So again, the point that the reflective loss principle is based on the ability of a shareholder to require a company to act. And then finally, paragraph 89, you'll see his conclusion. So, as Lord Justice Phillips anticipated, I now have to explain how those principles apply on the facts of this case. In our submission, the principles explained by the Supreme Court in Marex demonstrate that the rule in Prudential does not apply to former shareholders. The first point is this. The rule in Prudential can only apply where the company has a cause of action, and were it to exercise it, that would compensate both the company and its shareholders. And in our submission, in respect of a claim by the company, an award of damages to the company will not remedy the loss suffered by a former shareholder, because they are former shareholders with no remaining interest in the company. Whatever sum the company recovers will not be to the benefit of a former shareholder. Second point. The rule in Prudential is premised on the fact that a shareholder can exercise rights of control over a company's decision-making. And obviously a former shareholder has no such rights. It cannot require a company to bring a claim.
Now, are you talking about a former shareholder as at the date the cause of action accrues?
No. I'm going to come to
Well, that's the key
Promeo.
here,
It is. You forgive me for taking it in bits. I'm going to come to Promeo. When I come to Promeo, that's when I'm going to deal with.
So when you're saying former shareholder, you mean as someone who is a shareholder at the date the cause of action accrues, but ceases to be a shareholder thereafter?
No, my submission is it's a former shareholder at the time when the loss is said to be suffered by that former
This is all
shareholder.
linked with your argument that there's no damage, relevant damage, until
Correct.
crystallisation.
Until it is suffered by upon redemption, yes. I will come to Promeo. If what I'm trying to do in order to make this manageable, not least for myself, is to do Marex and to make my submissions, and then I come to Promeo, where I have to deal with 2 points: the timing issue, and the why is this different from a shareholder who has merely sold his shares on.
I mean, sometimes to get to the top of the mountain, it's easier to go around slowly, but you can go straight up.
I understand, but for me, if you bear with me, the slow route is.
Right, just the other judges will have understood, but just tell me again, who are you referring to when you use the expression former shareholder?
It's, if you go back to paragraph 15 of our voluntary particulars.
Well, I'm happy to have it.
No, I wasn't going to take you to. I was going to say it's a person who has redeemed, in this case, its shares in the company, and as a result has received less by way of redemption than would have been the case if the infringement of competition hadn't.
But we have to be clear here. There's no doubt that if they were a former shareholder at the time the cause of action accrued, then we're not in the ballpark, are we? I mean, we're talking about a very specific situation where somebody is a shareholder at the time the cause of action accrued, and at that point could have exercised their rights under the articles to require the company to pursue that claim, but they didn't do so before they redeemed their shares.
Yes, they may have been a shareholder at the time the initial wrong was suffered.
They have to be.
Yes, sorry, a shareholder, yes, not a former shareholder. That's why I was just checking we're in the same
Well, if they're a former shareholder, then we're just not talking about
Yes.
We're talking about
Yes, absolutely, sorry, I understand.
We're talking about somebody at the time the cause of action accrues.
Yes.
They are full square within Marex.
Yes.
And your only question is whether, if they subsequently, after the cause of action has accrued, and at a time when they could choose, if they so wished, to exercise their rights as a shareholder, to get the company to pursue the claim, and they would then be compensated through the usual mechanism. They decide, rather than doing that, they decide to redeem their shares.
Well, it may not be as knowing as that, because of course they may not know that a wrong has occurred at the time they redeem. So it may not be a willful choice, which is, I know that a company has a cause of action and I could seek to require it to bring the claim, but I'm not going to do so. So I do draw the line there. They may not have knowledge.
What I'm trying to understand is whether you accept that you are talking about people here who at the time of the cause of action accrues fall full square within Prudential, Johnson & Gorwood and Marix. And what you're really arguing now is a new point, which is, yes, well, that is the case when the cause of action accrues, but...
sorry, when the wrong is done.
When the company's cause of action accrues.
Yes.
Which is the key thing.
Well, I'm going to make submissions on
well, exactly. You're saying, in fact, there is a qualification to all this, which is if the shareholder, who on day one follows the fortunes of the company, to use Lord Kitchen's word, exercise his rights, whatever they may be, to require the company to exercise its cause of action, enforce its cause of action, he will be fully compensated. And you're saying that if in fact he doesn't do that, for whatever reason, but redeems his shares, and at that point his loss is crystallised, he at that point acquires a cause of action and a loss which isn't caught by Prudential Marix.
Correct. And also,
that's the point.
And also that the company cannot sue for that loss.
Well, that's for your point.
Yes, that's my submission, of course.
That's
yes.
the key point.
Of course.
So you can't be sued by current shareholders, you say, but you can be sued by former shareholders.
Yes, that's why we draw the distinction in the...
Right, and you're going to, when we come to this, show us how this distinction played out during the hearing below.
The whole argument below was just about former shareholders. It was this argument.
Can I answer something here? Are we talking?
Sorry, can I just finish? Of course, we didn't Promeo in the Privy
Yes,
Council.
I understand the ground
apply below,
shifted.
so on that one we have to shift.
Yes.
But are we talking purely about shareholders who've redeemed, or also talking about shareholders who've gone into the market and sold?
I'm going to no. Our argument does not cover shareholders who've sold their shares. It
So
only covers those who've
so
redeemed.
it's simply redemption.
Simply redemption.
Thank you.
So I've given you two submissions. The third submission is that the compensatory principle requires the court to avoid overcompensation, and therefore to the extent that the company has avoided, mitigated or passed on any part of its loss, its damages should be reduced accordingly. And I remind you, I'm afraid yet again, of the assumed factual basis of these appeals. It is that an investment fund, as a result of the wrong to it, has paid a redeeming investor a lower sum than would otherwise have been the case absent that wrong. And in our submission, if the company were permitted to recover damages without taking account of the fact that the infringement had caused it to pay out less by way of redemption payments, the company would be overcompensated. The fourth point is that where a shareholder suffers a loss separate and distinct from that suffered by the company, caused by a breach of duty independently owed to the shareholder may sue to recover the loss caused to it by breach of the duty owed to it. Applying that to this case, in our submission, the company must give credit for the reduced payments made to redeeming investors as a result of the wrongdoing. The company itself cannot claim for those reduced payments, the reduction in the payments made to the redeeming investors as a result of the wrong. Only the redeeming shareholder can sue for that loss. And it is therefore a loss that is separate and distinct from that of the company, because the company cannot sue for it. And the final point is that the rule in Prudential recognises the unity of economic interests which bind a shareholder and a company. But there is no unity of economic interest between a former shareholder and a company. On the contrary, there is actually a conflict of interests in relation to the quantum of their respective claims and damages. And that's because it's in the company's interest to minimise the extent to which it has passed on any loss. It is in the former shareholder's interest to maximise the extent to which any loss was passed on. So far from there being a unity of interest, there is a conflict between them as to where the loss lies in the chain.
For your, just so I've not misunderstood, You don't accept that the relevant shareholder has any cause of action at the time of the wrong. Is that your position? That
That's correct. Not for
he's-
the reduction in the value of the shares.
So it's
So how does this work? There's a moment in time where a wrong is done, and you have two shareholders who are who have shares in the company, one of whom remains a shareholder, and one of whom subsequently departs.
Yes.
And you say that the juridical consequences of those two situations are different.
Yes, I say that in relation to the existing shareholder, the current shareholder, they have powers under the Articles of Association to require the company to bring a claim. And if the company brings a claim and is successful, the damages will compensate both the company and the shareholders,
Yes.
because they are as one.
I understand that, but I've got past that.
That's right.
That
And then-
point in the argument. But I'm just asking you then, as my lord did a moment ago. So the key point is whether the moment at which the sale or the redemption of the share took place has anything to do with it. This entirely turns, does it not, upon when the right moment to judge
That's
this
right.
is.
And that's
because
prevailed.
if it was at the time the wrong was done, then there's no coherent basis for distinguishing between somebody who is and remains and somebody who is and departs.
That's right. If the relevant time for asking whether the reflective loss principle applies was the time when the company suffered its loss, or the time when the wrong was done, this argument would not fly.
Right. But it's necessary in order to distinguish the one from the other that the crystallisation point that was accepted by the judge is also accepted by us.
Yes, that there is an independent loss upon redemption.
And when the company suffers a wrong, the company suffers a loss, the shareholder at that point does not suffer a loss.
That's what
its
Lord
loss
Reid
is
tells us in
reflective.
tradition. Yes. No actionable loss on the part.
No actionable loss.
Or no loss recognised as distinct.
Exactly. And your argument is, when it redeems, it then somehow suffers a loss without any further wrong being done. So in other words, it suffers a loss
Consequent upon the same wrong.
consequent upon the same loss, even though the company already had a cause of action which would have compensated it if it had been enforced.
Yes, and if the company had brought the claim whilst the person was still a shareholder, they would obviously have no claim, even after they'd redeemed.
and that is not a mere conversion that falls foul of the authorities on conversion.
I'm sorry, you need
The
to
argument
unpack the
that
point.
Mr. Demetrio, the authorities to which we were taken, which is to the effect that you can't subvert the prudential FOSS rule simply by converting.
Well, I'm going to come to that, absolutely.
Yes.
So I'm going to come now to Premeo, which deals with the timing issue
Yep.
and deals with the situation of a shareholder who sells its shares. And I think that's moving into the territory of the questions you've been asking me.
Thank you.
So Premeo, Authorities 5, tab 49. And I can show you it very quickly. If we go to page 1501. So we need to begin at 1500. Paragraph 55. And what that tells us is, first of all, the rule in prudential is a rule of substantive, not procedural law. I need that when we come to the second part of the argument, the EU law. But for present purposes, it tells us that whether the rule in prudential applies or not must be assessed at the point in time when the claimant suffers loss arising from some relevant breach of obligation by the relevant wrongdoer. So not when the company suffers the loss, but when the claimant seeking to bring a claim suffers the loss. So that it goes, claimant brings a claim. One looks at when the claimant suffers the loss, and one asks whether the reflective loss principle
Forgive me, the
applies.
whole point is that the whole premise of this is that the shareholder does suffer a loss. It's just not one which is recoverable.
So the whole premise of the rule
Of the reflective loss principle.
yes, I'm going to, I accept that, and I'm going to come to that.
But distinguishing between when the claimant suffers and when the company suffers doesn't help because the whole point is they both suffer it at the same time.
No, but that's the submission I'm going to make to you. My point in Promeo, it's to be assessed at the time the claimant suffers the loss. It's not to be assessed at the time of the wrong. It's not to be assessed at the time when the claim is brought, which was the flaw in Nectris.
Well, not necessarily at the time of the breach. I mean, they may coincide.
Yeah, of course, sorry.
But yes.
So, time when the claimant suffers loss. And then you have, again, you were shown it at paragraph 61. You can pick it up on page 1503. So paragraph 61, you'll see the reference to Mr. Gillis's submission about halfway down that paragraph. There's a reference to a shareholder who sells his shares cannot avoid the reflective loss principle merely by that sale.
And what's your answer to that?
I'm going to come to that. I'm just taking you to the 2 points in Promeo I have to meet. So the application in this case. First of all, the question of whether the rule in Prudential applies must be assessed at the point in time when the claimant suffers loss. Not at the time when the wrong was done. Now, as a matter of general principle, in our submission, it is uncontroversial that a single wrong may cause different heads of loss suffered by different parties at different times. And you saw that, one sees that in Sainsbury's and MasterCard with the classic competition law pass-on type claim, where there is a supply chain. So a wrong is done to the person at the top of the supply chain, which results in an overcharge. And that overcharge then goes down the supply chain. It may go in total all the way down, or it may stay at various parts of the chain. But what we know from Sainsbury's and MasterCard is that each of those persons in the chain who suffers loss has a right to claim. Now, the loss that each of them suffers is not suffered at the time when the initial wrong is done. The loss which is suffered by each of those persons happens at the time they, for example, pay for a service or product in the chain. So you have an example of a wrong which takes place here. You have a chain of persons with a claim, and each person's claim arises at a different time from the same wrong. And that is absolutely uncontroversial. Now, I accept.
But it's not, that is controversial. If you just look at contract and breach of statutory duty, where damage isn't a necessary ingredient of the cause of action, the cause of action arises when the breach occurs.
But we're here our claim is dealing with breach of statutory duty. The claim that's brought against us is breach of statutory duty.
You don't need damage to complete that cause of action.
So you do need damage to complete.
You do?
Absolutely, yes.
Right.
Absolutely. It's you don't have a cause of action without damage for breach of statutory duty.
Thank you.
Now, I accept that at the time when the wrong is committed, an existing shareholder does not suffer any loss distinct from that of the company. Our case is that when a shareholder redeems its shares and the sum received is lower than it would otherwise have been absent the wrong, the company has to give credit for those reduced payments in its own claim and cannot sue for them because of the general principles of avoided loss, mitigation, pass on. And the shareholder suffers a loss distinct to it, which only that former shareholder can sue for. The company can no longer sue for that loss. And that's why, applying the test in Promeo, the loss on the part of former investors, former shareholders, is suffered when they redeem their shares, not at the time of the alleged wrongs.
Explain why is the position of a former shareholder who's sold is different from a position of a former shareholder who's redeemed?
So we're starting from the statement in Promeo that a shareholder which suffers a loss in the form of diminution of value of its shareholding, which is not recoverable as a result of the reflective loss rule, cannot later convert that loss into one which is recoverable simply by selling its shareholding. And we say there are material differences between the situation of a selling shareholder and a redeeming shareholder. Let me deal first of all with the case of a selling shareholder. So in a case where a shareholder sells its shares to a third party, first of all, the company will still be able to claim for the full extent of the loss caused to it by the wrong, and the third party shareholder will have the benefit of any such claim. And indeed, the buying shareholder, if I can put it like that, will also have rights under the Articles of Association to seek to require the company to bring a claim if it so wishes.
A different shareholder.
Yes, a brand new shareholder.
Yes, we'd have the rights. Yes,
Yes, but the one who sold his shares doesn't have the rights anymore.
no, that's right.
And he's the one who
I'm distinguishing. So I'm giving you the situation. Imagine a situation where a shareholder has sold its shares to a new purchaser, to a new shareholder.
Yes. So
And the question is...
the shares are still there.
Yes.
It's owned by a different person.
Correct. And the question is whether there, and we know from Marex that the reflective loss rule would apply to prevent a claim being brought, either by the existing shareholder, by the former shareholder or the new shareholder. And the reason why we say the situations are different, I'm first of all going to deal with the situation of sale of shares. And the first point is the company will still be able to claim for the full extent of the loss caused to it, and the new shareholder will have the benefit of that, and the new shareholder, if it wanted, could seek to require the company to bring that claim. So, as you said, the shares still exist and they still give those rights.
Point one, that's Park. The company hasn't, its loss hasn't been avoided.
Mm-hmm.
Point two, why does the fact that a new shareholder can enforce and get a windfall remove the point that the old shareholder no longer has any remedy?
The point that's important is that the company can still sue for the loss that it has suffered. But the second point, which you've just diverted
but the old shareholder will not get compensated by that.
No, well, not. That's the point. That's the point.
So why does that? So on your analysis, why does that mean that he can't claim?
Sorry, my submission is that the former shareholder can claim. So you're asking me about the new shareholder or the selling shareholder?
Former shareholder who has sold his shares.
Who has sold the shares, sorry.
Can claim. I thought.
No, I think we're at cross purposes. I thought you were talking about a redeeming shareholder. So my submission is it's quite clear from Marex
Yes.
that a shareholder who has sold his shares to a third party is blocked by the reflective loss principle from bringing his own claim.
I understand that. I'm just trying to understand why you say it's different from a redeeming shareholder.
And that's what I'm going to give you 3 points which are characteristic of a situation in which a shareholder has sold its shares. And I'm going to distinguish that from a situation where a shareholder has redeemed its shares.
What you're going through is you're trying to explain why on those factors it's right that he shouldn't claim.
That's right, because I want to show you that if one takes the principles which underlie the reflective loss rule, which we know from Marex, those factors, those principles do apply to a sale of shares, but those principles do not apply to a redemption of shares.
But one of them was, that as I understood it, you made it very plain that one of the points about prudential is that if the company recovers, it will compensate the shareholder.
That's right.
But it will not compensate the shareholder who has sold.
That's right.
So why on that basis wouldn't there be a claim?
Because where the share is sold, the notion of the company in terms of what the shareholding gives is still held by the new purchasing shareholder.
So what?
There is
101 says that
the second
applicable that he has to be compensated.
The second point is that in this circumstance, the company would not be required to give credit in its claim for any reduction in the selling price of the shareholders' shares as a result of the wrong. There's no loss avoided by the company. The company's cause of action is for the whole of the loss caused to it. without taking account.
You're going to say it's different with a redeemed shareholder because the company's avoided its loss.
Yes, that's right.
So we do have to look at avoided loss.
Because when the company, in our scenario of the sold share, the company brings its claim.
Yes.
The company brings the claim for the whole of the loss suffered by it without having to account for the reduction in the sale of the shares by the selling shareholder. Therefore, the company recovers the whole of its loss. And if the selling shareholder was also allowed to bring a claim, that would lead to double recovery because the company is not required to give account for the reduction in the value of the sale of the shares. It recovers, taking no account of that. And if you were to give a cause of action to the selling shareholder, there would then be double recovery because it would be recovering in part of the same loss that the company is recovering from.
I understand that, but the distinction then is that you say that the company, in the case of a redeeming shareholder, has avoided its loss.
Exactly. It cannot claim for the lower sums it has paid out as a result of the wrong by way of redemption.
Because of avoided loss.
Yes. And that's what we say is the difference. So put it another way, if you take the principles in Marex that I've identified and you apply them to a share of sales, they fit perfectly. There is no problem. But you have my submission as to why if you take those principles and apply them to a redeeming shareholder, there is no match. The reflective loss principle cannot apply to a redeeming shareholder. Those are my submissions on the principles that apply, that one gets, the principles that underpin the reflective loss principle. There's another argument which is put by the claimants, which is based on the statement in Marex, for example, at paragraph 89 by Lord Reid. I'll read it out because you've seen it. The rule in prudential is limited to claims by shareholders that as a result of actionable loss suffered by their company, the value of their shares or of the distributions they receive as shareholders has been diminished. And the argument that's put by the claimants is that the words, the distributions they receive as shareholders, encompasses payments, redemption payments. And our submission is that there is a clear distinction in law between distributions received as shareholders and sums received by way of redemption of shares. First of all, redemption and distributions are entirely distinct concepts under the Companies Act 2006. Can we go to Authorities 1, tab 9? Page 132.
Are all the companies here English companies?
No. But I'll show you I'll show you an example of the particular articles of association to show the distinction.
Just be a convenient moment to have our 5-minute break.
It would.
Just if we're moving on to this,
Of course,
this passage.
All right. Just a gentle reminder that the live streaming will not be switched off as it's only for 5 minutes.
London will start. Winter on Mars.
All rise.
So we're about to look at the Companies Act 2006, which is Authorities Bundle 5, tab 43. I'm going to pick it up at page 132 of the bundle. Authorities, Bundle 5, tab 43. So have I given you the wrong?
Sorry, it's bundle 1, tab
I'm
9.
so sorry. I've given you Marex
No,
again.
I had a
Sorry,
moment there.
we're all going a bit.
One tab.
Authorities 1, tab 9. I'm so
And
sorry.
work internal.
Internal page 132.
Thank you. 684.
That's right, 684. Now, slightly oddly in the way this is printed out, the part of the Act to which it belongs is below the section rather than above the section. But if I can ask you to look above the sentence Crown Copyright Material, you'll see Part 18, Acquisition by Limited Company of its own shares, Chapter 3, Redeemable Shares. So this is the part of the Act that is dealing with redeemable shares. And then you see section 684 sub 1, if you could read that please. And then 685 sub 1. And then 688 on page 136. So redeemed shares are cancelled, which of course is different from when sales are merely sold to a third party. So there's a section of the Act that deals with redemption, and then there is a separate part of the Act that deals with distributions, and that's at page 139. And again, slightly oddly, the heading is at the bottom of the page. You'll see this is Part 23, Distributions. And if I can ask you to read 829 sub 1, and actually sub 1 and sub 2, you'll get a flavour.
Yes.
So, two separate concepts in company law. The distinction is also reflected in the Articles of Association of the appellants in this case. I'll just show you one example. We go to Supplementary Bundle, tab 12.
Mr. Hoskins, for my part, I don't have any difficulty in the technical distinction between a distribution and a redemption. The question really is whether or not Lord Reed in Marriott had such a technical distinction in mind, and surely one has to look more at how that fits in with the principles that he was espousing, rather than the technical way in which you.
I'll gladly. That's my submission, my lord, because I've made my submissions on the principles in Marriott. So my submission, if I'm right on the principles, it can't be the case that just because Lord Reed used the reference to distributions they receive as shareholders, that could change what the answer would be on the principles. So my submission, I'm grateful, is decided on the principles, not on what those words may or may not mean taken out of context. They have to be understood in light of the principles.
Well, I think I understand it may say looking at some references, but I'm not sure it's. I'd suggest one view of it is that what Lord Reed had in mind are payments out to a shareholder, whether by way of dividends or any other payments out, which the quantum of which reflect the fact that the company has suffered a wrong.
Well, you have my submissions, what the principles are. I'm not going to repeat it. The company has a cause of action that would compensate the shareholder, that the shareholder has a right under Articles of Association to require the company to bring the claim. My submission, the reference to distributions has to be understood within or on the basis of the fundamental principles, which is why we're all here today. That's what I wanted to say on company law. Unless there are any further questions, I was going to move to the trust issue now. Thank you. I can sort of jump into this, I think, because in the transcript yesterday, this is for your note, page 87, lines 9 to 11, Ms. Dimitriou said, we accept in principle that if a separate duty is owed to the beneficiary and the beneficiary has suffered a loss, then the beneficiary will be able to sue. In our case is actually a bit more refined than that, but we agree with the basic premise there, so there's common ground between us on that. But we say there are two distinct questions. The first one is, does the tortfeasor owe a duty to the beneficiary? And the second question is, did the beneficiary suffer loss distinct from the loss suffered by the trust as a result of the breach of that duty? And those are two separate questions. You don't mangle them together. You ask, is there a duty owed to the beneficiary? And you ask, has breach of that duty caused loss, which is distinct from that of the trust? Can I take you to Lewin on trusts? That's Authorities, Bundle 7, tab 70. We can pick it up at page 2035. Could I ask you please to read 47001, heading Trustees Normally Proper Claimants.
Sorry, Authorities Bundle 5.
Authorities Bundle 7,
7.
tab 70.
001, the whole thing.
Please, yeah. Trustees Normally Proper Claimants.
So, 203.
Thank you very much.
Yes.
So, as I've indicated, there's common ground between us. The general rule is only the trustee can sue for damage to trust property. It's possible there may be a derivative action by a beneficiary on the part of the trust. But thirdly, sometimes a personal claim in tort is available to beneficiaries of a trust. You'll see that just below the middle of that paragraph. And then, if we go to page 2042, and if I could ask you to read 47018, and here are some examples of when a beneficiary may bring an action in its own right for loss that it has suffered.
There's three circumstances in which maybe you...
That's correct.
So, well, do we need to... I mean, how long...
No, so sorry,
that
just
go on for?
47018, that's it, that paragraph.
Right.
And then, so I'm not going to go through all of them, so I'm going to go to the third one, page 2044, 47023, and if you could read over the page until you get to footnote 80.
Assumption of
please.
responsibility to beneficiaries.
That's correct, and you can stop it when you get to footnote 80.
Thank you. Yes.
And you'll see the reference in footnote 80 is to Ute and Leonard Ross. And if we can go to that authority, that's at Authorities Bundle 2, tab 25. If we pick it up at page 516, there's an editor's note, which I have great sympathy with. The facts of this case are extremely complex, but you could have read the rest of it down to G, please, down to responsibility towards the owner. Then we can see how Mr. Justice Ferris actually analyses the case. He addresses the two questions. Is there a duty? Is there loss distinct from that of the trust? First of all, is there a duty? One finds that on page 558. If you could read from B to E. It begins beneficiaries under a disposition by way of trust.
I think I got the wrong page.
So it's page 558.
Yes.
That's internal.
Sorry, 576 internal and 558.
Thank you, sorry.
Thank you.
I am generally giving authorities bundles or trying to.
Yes, I'm sorry.
So 558, B to E, is addressing the question, is there a duty owed to the beneficiaries? And then, the 559, between C and F, he then addresses the question, did breach of that duty cause loss to the beneficiaries distinct from that of the trust? And the answer was yes, because they had incurred expenditure on their own expenditure.
Sorting out the predicament.
Indeed, of the complicated facts that are too complicated to summarise. So I cite this, as do the authors of Lewin, as an example of a case in which a beneficiary may sue a third-party tortfeasor, one, which shows it's an independent duty, a duty owed to the beneficiary, and two, where breach of that duty has caused the beneficiary to suffer loss distinct from that of the trust.
Well, that then just brings us back to the same question.
Just go back
whether
head to
loss
the
is
same
distinct.
place, yeah. I want to show you that the principles in trust, the application is going to be the same submissions, but I need to show you the law on trust to show you how it's set up. And indeed, we're aided by Mr. Meacher's indication yesterday that they accept that there can be instances. And then the question is this one of those cases? So just briefly, two other authorities that have been referred to. First of all is Chappell against Summers and Blake. That's authorities tab 2, so this same one, but at tab 28. And this was the head note at page 678. The claimant, who was the sole executrix of the deceased will, retained the defendant firm of solicitors to act on her behalf for the administration of the estate. And then opposite D, she brought an action against the solicitors, alleging breach of their contractual and tortious duties to her, and claiming damages in respect of inter alia, the loss to the estate resulting from the failure of the properties to produce an income during that time. The solicitors applied to strike out that part of her claim. Now, this is one of the authorities relied upon by the claimants in support of their case. But in our submission, it doesn't assist them, because if one goes to page 682, it's the judgment of Mr. Justice Newberger, as he then was. Opposite G, you'll see the second possibility. The second possibility is that the beneficiary is entitled to sue the solicitors for any loss suffered. The problem with that argument is that the solicitors plainly owed no contractual duty to the beneficiary, and there must be considerable doubt as to whether it would be right as a matter of principle to impose any tortious duty to the beneficiary on the solicitors. So all this case tells us is that where a duty is not owed to the beneficiary cannot sue. It sheds no light on the question, what if they did have a duty owed to them? But there's clearly a suggestion that if they did, that would have altered the analysis. And Webster is exactly the same.
And so this all turns, from your point of view, on establishing the duty under Article 101.
Correct.
Thank you.
So if we go to Webster, Authorities, Bundle 3, tab 32. And you were shown the facts yesterday. I don't need to dwell on them. And you were also taken to paragraph 31 at page 806 of the bundle. And again, in our submission, all this tells you is that if a tortfeasor does not owe a duty to a beneficiary, the beneficiary may not sue. But of course, by virtue of that reasoning, the inference is that if a duty is owed, they could sue. You see that particular, the last sentence. A beneficiary under a trust does not have a direct cause of action in negligence against a person who may be liable to the trustees. But that's a particular aspect of duty of care and negligence. And of course, that's the field wherein we have a separate question as a matter of competition law, is a duty owed to the beneficiaries. I'm going to come to deal with the Australian case, but first of all, I'd just like to make clear what our case is on this. So I'm applying these principles to this case. And as Lord Justice Phillips has anticipated, it's the same path I trod in relation to the company law argument. But first of all, importantly, first question, does the tortfeasor in this case, i.e. the banks, owe a duty to the beneficiaries of the trusts? And as I've shown you, Garden Cottage Foods establishes that an undertaking which infringes Article 101 TFEU is under an obligation to pay damages to any party which suffers loss as a result of that breach. And as I've shown you, it's accepted by the appellant that that's the same position in relation to Section 2 of the Competition Act. And that cause of action arises by way of a breach of statutory duty or directly to the person who suffers loss as a result of the infringement. That's Garden Cottage. So in our submission, the first question is answered in the affirmative here. And the next question is whether there is loss suffered by the beneficiary distinct from that of the trust. And I'll say it quickly, but you have the point. We're dealing with an assumption that as a result of the infringement of competition law, the beneficiary receives lower redemption proceeds than would otherwise have been the case absent the infringement. That's the assumed fact. Any claim by the trustee against the respondents would have to give credit to the extent that the trust paid less by way of redemption proceeds to a beneficiary as a result of that infringement. Payment of a lower redemption sum to the beneficiary is therefore not a loss to the trust. It cannot sue for it as a breach of statutory duty. But receipt of lower redemption proceeds is a loss suffered by the redeeming beneficiary, which the trust cannot claim for. It is therefore a loss to the beneficiary, which is distinct from any loss suffered by the trust.
So that's an assertion that it's distinct rather than reflective.
That's my submission as to why it is distinct, yes, and not reflective. It's because the trust could not claim for that loss. And if the appellant's arguments were correct, and the trustee could claim damages without taking into account any reduction in redemption payments it made as a result of the wrong, and if the redeeming beneficiaries could not claim in respect to the reduced payments they received, that would mean, first of all, that the trust would be overcompensated by recovering more damages by way of breach of statutory duty than it had otherwise suffered. The former beneficiary couldn't benefit in any way from the damages recovered by the trust because it is no longer a beneficiary in the trust. And on the appellant's case, the former beneficiary would have no means of seeking to require the trust to bring a claim in respect to those losses in any event because it is no longer a beneficiary. So it's an analogous argument in relation to the reflective loss principle in company law.
So these losses were incurred by the companies over an extended period of time.
By companies or trusts, just to center.
Companies or trusts, by the principal,
By the funds.
by the claimants. And over that period of time, the shareholders or beneficiaries will have been continually changing. And also over that time, some of shareholders and beneficiaries will have redeemed. Some will have, and new shareholders will come into it, or new beneficiaries. So and also this action, which started in February 2020, may take a little while to resolve the current case. And your contention, it seems to me, is that what's got to happen here is that there's going to be an exercise where working out what the losses of each of these wrongs are, you have to work out who were the shareholders at that time. And then look at whether any of them have redeemed, and work out how much their shareholding was diminished by virtue of the wrongdoings which had been occurred up to that point. Which in itself will be a nightmare exercise, because you're going to have to work out to what extent the fact that the company may have a claim at various points will have reflected the value into the value. And which is a historic exercise, it's going to be a continuing exercise. It seems to me, even right up to the day before judgment is given, if somebody redeems their shareholding, that means that they acquire a fresh cause of action against you, which they can sue you for, but correspondingly the claimant's claims are reduced, or some of the claimant's claims are reduced. This is a recipe for total chaos, and entirely vindicates the principle and policy which underlie the decisions here, don't they? I mean, this would be utterly unmanageable in a case like this.
Two submissions in relation to that. I showed you the Supreme Court in MasterCard and Sainsbury's and the difference between the approach in American law and English law.
Yeah.
And I made the submission that it is quite clear from that judgment that the Supreme Court believes this is a matter of principle rather than, if I use shorthand, legal policy. So the fact that some...
different. Sainsbury's and MasterCard is looking at pass-on.
It's looking at pass, as you well know, it's looking at pass-on. The argument there was, had Sainsbury's passed on the overcharge it had suffered as a result of the services for credit card, the payments for credit card services provided to it by banks,
Yeah.
to its own customers when they went into Sainsbury's and bought groceries. So the number of potential people to whom it was passed on was enormous. The nature of the pass on to each of them would have been different. But what the Supreme Court did not say is, because of that complexity, the defendants cannot raise this point.
Well, it's entirely different, isn't it? I mean, you'd look at the myth, and you'd then have an accounting exercise to work out to what extent the myth had been passed on to the customers through increased prices. I can see that could be an exercise which would require a certain amount of evidence, of which there is no shortage in those cases. But this is a different order of exercise, because it's not going to be done in broad terms, looking at MIF rates and their impact on the retailer's price calculations, which I suspect will be done on the basis of fairly broad evidence. This would require detailed examination of each and every transaction which was undertaken with the shares in the claimants or the beneficial holdings over many, many years, all with a view to chopping bits off what is undoubtedly the claimant's losses, and transferring those losses to individuals. I mean, it seems to me the only sensible way that one could really deal with this, if it was seriously proposed, would be to have some form of class action running in parallel by the former investors to mop up that argument, and then it would all come to naught, because it would either be recoverable by the claimants or by the individual investors who could claim at the same time. At the end of the day, you're liable for the same sum.
I understand.
It's a matter of.
I understand that, Muller, but you have my submission. This has to be decided, because the Supreme Court has told us, as a matter of principle, not legal policy.
Well,
now,
everything has to be dealt with in a matter of principle.
That's
to a
right.
certain extent, but there are policies underlying the reflective loss rule which weren't being considered in Sainsbury's and Mastercard.
So, if we're to say so, how is it to be decided in this case? You have my submissions on the principles that underpin the reflective loss principle.
Well,
I've
we have. I mean, what's
can I finish? Because I just don't feel I've had a chance to answer your question yet. I have my legal policy versus principle. And my second argument is that the law itself, and again one saw this in the Supreme Court in Sainsbury's and Mastercard, has ways of dealing with such issues of complexity. And that principle is the broad axe, which again you'll be well familiar with. And one of the issues that was decided by the Supreme Court in Sainsbury's and Mastercard is that the broad axe, i.e. the court doing the best it can on the evidence it has before it, can be wielded by a defendant who's arguing pass on just as much as it can by a claimant. Now, when it comes to the disclosure exercise, if these pleas are not struck out, there will be, no doubt, arguments before the judge in charge of this as to what sort of disclosure is proportionate. And that argument will take place, but that is not a matter for this court. This court is concerned with principle, but insofar as there are obviously practical issues going forward, my submission is the scope of proportionality will be decided by a judge, and the extent to which these issues have to be gone into will be assisted by the broad axe principle.
Well, as the question of principle is concerned, it seems to me isn't the reality of what's happening here is that we've had a number of cases which have looked at the reflective loss principle. There was an attempt to poke a hole in it in relation to shareholders who'd sold. That has been that has not been accepted by Primeo, and you're now trying to find a way through, poke a hole in it for redeeming shareholders.
No, I put it the other way.
You have to look at that as a matter of principle as well.
Well, yes, but I put it this way. From paragraph 9 of Lord Reid in Marex, the general principle is a person who suffers loss as a result of a breach of duty owed to him has a right to claim damages. Then the reflective loss principle is an exception, which is to be narrowly construed. It's an exception. In our submission, if you want to turn this around, what the claimants are trying to do is extend the reflective loss principle into a place it will not go because of the principles upon which it is based. Because, in this case, the company cannot sue for the loss that the redeeming shareholder has suffered.
Well, that's dependent on avoided loss.
Well, you have my submissions. You have my submissions.
But if
you raised with me the issue of
again,
complexity.
it's the whole thing. If the whole of your edifice depends upon the contention that after redemption the company may have avoided its loss, I'm really not sure how one can get very far without grappling with that.
Well, it's three routes that might cause the company to have a reduction. It's mitigation, pass on, avoided loss. And I've shown you the Supreme Court in Mastercard and Sainsbury's, which says in terms, the law mandates a court to take account of pass on of loss. And that's what I'm asking the court to do. That's the edifice upon which my argument is based. That English law requires a court, mandates a court to take account. And the reason why it does that is to comply with the compensatory principle to make sure that the company is not overcompensated for losses that it has not suffered or for benefits or advantages it has gained as a result of the same loss.
Thank you.
I think from that exchange I have at least hopefully set up the framework that will allow you to decide the case. You have my submissions, work should be in my favour, but I think we're at D-Dem in terms of what the issues are and the framework indeed. Partnership, again, we can take quickly because it echoes the arguments we've already... Oh, sorry, I said I go to the Australian case. I need that before we go to partnership. So this is the Supreme Court of Victoria in the case of Young and Murphy. That's Authority 6, tab 62. now just to explain, the Supreme Court of Victoria is the highest appellate court in the state of Victoria. Appeals lie from it to the High Court of Australia. So we're not dealing with the highest tier in Australian jurisprudence. In our submission, this authority does not address the situation where a beneficiary has suffered distinct loss from the trust to it as a result of a duty owed directly to it. Now, the facts are quite complicated, but let me show you why the point we are dealing with doesn't arise in this case. First of all, at page 1846, we were shown this yesterday, so just to refresh ourselves, a trustee company, BPTC, was replaced as a trustee of an investment unit trust, and the new trustees brought proceedings for breach of trust against BPTC and various other defendants. And the defendants, other than BPTC, challenged the new trustees standing to sue BPTC. And the court found that the new trustees did have standing to sue BPTC for breach of trust, notwithstanding changes in the identity of the beneficiaries of the unit trust since the breaches of trust. Can we go to, it's internal 295, 1862 of the bundle. And if you look at line 25, sorry, picked up at 24, in paragraph 21, it is alleged that by reason of those breaches of duty, the assets of the trust were lost or diminished and remain lost and diminished. BPTC is said then to be liable to account for such losses and make good the assets of the trusts, and the respondents claim to sue as current trustees to enforce the obligations of BPTC. And then, importantly, if one goes down to line 43, you see, for present purposes. That is sufficient to describe the way in which the claims against BPTC are pleaded. The appellants relied upon the fact that the pleading asserted only that the assets of the trusts were lost or diminished and remain lost and diminished, and that there was no allegation of loss suffered by any particular unit holders or any particular class of unit holders. So in that case, the beneficiaries were not claiming for loss suffered by them, distinct to them, from the trust. And that's why Young and Murphy does not deal with the issue that is before this court. The claimants also relied on CPR 19.7a. You had, Lord Justice Phillips had the exchange with Mr. Mitru, and in our submission, notes to the White Book cannot trump the law, and I've shown you the law. Notes to the White Book certainly shouldn't even trump Lewin, which is the leading textbooks out. In our submission, the procedural rule in 19.7a doesn't take us anywhere in terms of principle. So on partnership, again, let's start with what's common ground between us. In submissions yesterday, again, I'll give you the reference and read you the extract. At page 96, lines 1 to 13, Ms. Demetrio referred to the Henderson Fund case. And in relation to that, she then said, and Mr. Justice Cook found that each limited partner has his own contractual or fiduciary claim for its own loss. And we accept, as I have said, that if a duty is owed to an individual partner personally, they can bring a claim. And this appears to be an example of such a case, because it is a claim by individual partners against the general partner for misuse of funds. So again, our case is actually a bit narrower than what Mr. Demetrio accepts. It's the same two questions that I put in relation to trusts. But you'll see the extent of the common ground between us. In this context, the two questions are, did the tortfeasor owe a duty to the limited partner? And second, did the limited partner suffer loss distinct from the partnership as a result of a breach of that duty? It's exactly the same rubric. So I don't think I need to take you to the Henderson case, given the acceptance of that principle that I wish to take from it by Ms. Dimitriou. So one has to apply again those principles to the facts of this case. And you have my submission in relation to the first question: is a duty owed to limited partners? And the answer is Garden Cottage Foods. A duty is owed by a person who infringes Article 101 to anyone who suffers loss as a result of the breach, as a result of that infringement. And then you have the question of, was distinct loss suffered by a limited partner distinct from the partnership? And here we're assisted by Lindley and Banks. That's Authorities Bundle 7 at tab 68. Now, if we pick it up at 1996, you see the heading of this chapter or section is the nature of a partnership share. That's right at the top of 1996. And then you'll see the subheading, the classic definition at 1905, and then there's a citation from Lord Lindley. I don't think we need to go into the detail of that. I simply want to show how the authors pick that up. And they do so at page 1998. It's the paragraph at the top of the page that begins, "Nevertheless, it is considered." If I could ask you to read just that paragraph. And you'll see the three categories, the three stages that are distinguished. So the same page, 1907 and 1908, there is a description of what the nature of a share in a continuing partnership is. If I could ask you to read, please, at 1907 and 1908. Top of page 1999, you don't need to read when you get to, I'll just read 1998. Yes. And then you'll see the final sentence in that paragraph on 1999, the foregoing analysis appears to have been accepted by the Privy Council in Hadley and in substance by the Court of Appeal in Popat. And then on page 2000, you see the heading Death, Retirement or Expulsion of a Partner. And if you could please read 1910. So you see that in relation to a retiring or redeeming partner, his share may properly be regarded as a pure debt from the date on which he ceased to be a partner. So we submit that it's clear that that is not a partnership asset. That is an asset personal to the retiring partner. And you have our submissions. We submit that in circumstances where an infringement of competition law has caused a redeeming partner to suffer less by way of redemption payment than would have been the case absent the infringement, that redeeming partner is entitled to sue for the personal loss caused to it as a result of the breach of competition law. And again, let's look at it on the basis of the appellant's argument. On the appellant's argument, the partnership would be able to claim damages without taking account of the reduction in payments to the redeeming partner. And in those circumstances, the partnership would be overcompensated, and the redeeming partner would have no means to bring his own action, no means to require the partnership to bring an action, and no ability to share in the fruits of any damages that the partnership brought if it did bring an action. Well, that would be a good place to stop. It's slightly shy of
How are you doing?
I think I'll sit down in time to give Mr. Teare a decent crack at your reply. I've now, I think avoided loss we've covered, to be perfectly honest. I'm not sure I need to return to it, but I say that now so that Lord Justice Phillips can ask me any questions. I doubt I'll need to actually go back to it. And then I'll move on to the second aspect of the case, which is the EU.
All right. Well, perhaps you just agree a rough and ready division of time for this afternoon. We'll, within reason, sit to however long is needed to complete the case, certainly up to 4:30 if that's necessary.
Thank you.